Mr. Wrench has pointed out that this is a case about traffic violations. Unfortunately, the outcome here was tragic. It was unnecessary, and certainly not what anyone, including the defendant, would have wanted to have happened. We have in the state a bond form that is used by the clerks of court to impose fines and penalties in certain cases. And in the case of these Class 2 misdemeanors, which are, has been pointed out, have maximum penalties involved of 30 days in jail or up to $500 in fines, the bond schedule that has been developed, which anyone charged with such an offense could go into the clerk of court's office if they were cited as such. And in the case of these two statutes that are at issue, the operating a motor vehicle while using a mobile electronic device, the fine and bond schedule has a bond set at $178.50, which includes fines and costs. As to the lane driving charge, the bond schedule has a fine and cost of $132.50. Obviously, this isn't the typical case, and I don't think that anyone would expect that Mr. Ravnsborg should walk away paying $178.50 and $132.50 on the two charges. And in the context of this case, I am going to deny the request for suspended imposition of sentence, and I am going to find him guilty of the charge in count 1 of operating a motor vehicle while using a mobile electronic device, and of lane driving charges as set out in count 2. Mr. Wrench is correct that even a suspended jail time is unavailable to the court, and no jail time will be imposed in this case. I am going to impose fines of $500, and I believe the court costs on the Class 2 misdemeanor are $66.50 on each count. I may not be correct on that. I didn't have to look at that. But in any event, I will impose those court costs as well as the $500 fines on each count. In addition, as a condition of the sentence, I do find that, and perhaps it's somewhat unfortunate from Mr. Ravnsborg's point of view, that, but because of the profile, the high profile of this case, I think that the various charges that the county is requesting here are legitimate with respect to the additional costs that are imposed. I think that certainly securing the area, had it been anyone else, probably wouldn't have taken that amount of cost. And certainly the high profile of the case led to perhaps greater examination and costs involved. I'm going to grant the restitution request of $3,742.38 to the county as not as restitution but as costs. And although I understand that a monetary award to the victim's family or the victim's mother may help assuage some concerns here, I think it's also correct that there's nothing the court's going to do that's going to make anyone happy in this case. I'm I'm going to deny the request for funeral costs. It appears those were paid by insurance or covered by insurance, which is the purpose for which insurance was brought, and I don't think it's appropriate in the context of this case. Any other costs of restitution or award are more properly handled, as been pointed out, through a wrongful death action, which I understand is being contemplated currently. Mr. Ravnsborg will have 30 days within which to pay any fines and costs. In addition, I am going to require that Mr. Ravnsborg do a significant public service event over a period of 5 years, once each year, on or about the anniversary date of Mr. Beaver's death.